Hi, everybody. Welcome to the Third Fridays podcast. This is going to be the July edition. And, we usually do this show as a 201 level accompaniment to our 101 level webinar series. So the webinar series is every third Monday of the month, and we talk about basic issues in workers' compensation in New York. And then the podcast comes in with this, hey, I'm bigger than you kind of thing. So I'm going to talk about next level issues in this podcast, like I would every month. So I thought, what could be more next level than going to the third department of the Appellate Division, which is something that we're doing more and more of due to the crazy decisions from the Workers' Compensation Board. And to kind of show you the importance and the significance of that process, we have two guests here today from our partners at PHP, Eric Kuperman and John McGorty. Welcome to the show, guys.
Thank you very much.
Thank you.
So, guys, tell us a little bit about what you do. John, I actually liked what you said earlier today when you said we exist so that you guys can focus on workers' comp, right? So, what does that mean? I guess.
Sure. I mean, our business plan, or again, like you said, why we exist is so that our clients, the attorneys, can focus on their clients' needs, dealing with them, digging into the actual written arguments leading up to the oral argument of the appeal. Our company, our support team, our paralegals, they're going to deal with everything else. So starts with helping you reproduce your record on appeal. Even before that, it could be to help you confirm a deadline, to buy more time for an extension, seeking an adjournment. We'll send you then a working copy of the record where then as you're writing your brief, you can reference the underlying record on review. And then once all of that is approved, your brief is all buttoned up. We're going to then help you serve it, file it, the e-brief, make sure that the e-brief is uploaded to the third department web portal. And just make sure, like I said, all the I's are dotted, T's are crossed, but allows our client to focus on the written argument.
That's great. And, this is almost like the post-game show. I don't know if you guys like sports, but right? Like you guys just gave an hour and a half long presentation to our firm as part of our training initiative with our new hires, our new attorneys and paralegals. Every third Friday of the month, we bring someone in to really make sure that we're not missing anything. We want to make sure that we're doing better every day, right? You guys talked today about new rule changes in each of the departments. So how difficult is it to constantly be aware of these changes in your field?
So the truth is, it's what we do. So we're tracking
Right.
the rule changes in all the departments. I know your practice at the firm is primarily or exclusively the third department, but we're tracking rule changes in first, second, third, and fourth department. There's even talk, by the way, in the second department of their expanding into a fifth department simply because of the volume
Wow.
that's handled by the second department. It's notoriously the busiest appellate court in the nation. And so that's what we do. We track these rule changes. We're in constant touch with the various clerks of the Appellate Division, various departments, simply because when a rule changes, they know, ultimately, the clerks of the court know that we will actually be handling the logistics of the filing, and therefore it frankly doesn't matter whether they let you know, Christian, that a rule has changed, when they know that
Right.
Christian is using PHP to ultimately file their stuff. So they want to be sure that we are up to date on the current.
That's a good point,
state of
right? Like
affairs.
having the credibility to really promote yourselves and make sure that everyone is on the same page. I like what you guys said about calendaring things protectively, almost, because I feel like we do that to make sure that we don't miss anything, and to have you guys as partners has certainly helped our practice. So for all our listeners, right, we usually talk about the first level of administrative appeal, right, before you guys are involved, and that is really just a time and expense function that is carried out for our clients. Now, obviously, you guys don't do what you do for free, right? But we talked a little bit about today about how the average appeal that we would give you is not the 15 bankers box or the 70 volumes of that truck that you just had, John, right? It's more in your 200 to 300 page record, right? So could you give our clients a sense of how much that would cost them in that type of appeal?
Sure. Based on the specs that you just mentioned, 200 to 300 page record with the average size brief, which again, I guess we all agreed, roughly 30 pages. I think that would put us in a range of maybe $4,000 to $7,000.
Right.
And again, it all depends on duplicative documents. If there are some exhibits that are shared, your 300 pages sitting on your desk could become 200, right? And it could also increase, but, I guess on about an inch of paper, around 225, 250 pages, that's the average cost.
And I think that's a really nice number for us because, knowing that the board is actually at a more alarming pace coming out with decisions that are really, really adverse to our position, that $4,000 to $7,000 range is, maybe seemingly unpalatable, I guess is a word, but when considering what we're actually going for, right, the amount of exposure we're trying to reduce, that's a good number, I think, to really use as an anchor and in comparison to what our hopeful result is, right? So if it's $4,000 to $7,000 as an additional expense on the file, but there's a possibility of recouping $100,000, then you guys are really making it worth it.
Correct. We actually we counsel our clients. I'll typically ask when an appeal comes up and I'm discussing it with an attorney. I'll ask what the value of the case is, regardless of the kind of case.
Right, because then you can tell them.
Correct.
Right.
I'll literally say, don't bother.
Right.
Because they'll tell me, well, there's a $25,000 on the line here. And I'm like, well, you're not going to spend $8,000 to try to go to maybe win $25,000.
Right. That's the point.
On the other hand, we handle appeals where the record's $40,000, $50,000, $60,000. But frankly, the litigation's over $250 million. So
right.
$40,000 is
just another drop in the bucket. Exactly.
Correct.
So let's talk about then, when you want to get involved, right? Your ideal scenario for a firm like us, right? When would you first want to be involved?
Right now.
Okay.
And I say that tongue in cheek, but not really, because the sooner we're involved on the front end, the easier it makes it for you when you're drafting your brief.
Right.
We don't want to be in a position where, we're up against the deadline, which is increasing your pressure with your client, and you've got to crank out that brief. But you can't crank out that brief in completion with citations to the record that John mentioned, putting a proof together, until we have the opportunity to put that proof together. So we're looking to get the documents from you as soon as possible, as soon as you're really ready to give them to us. That gives us time on the front end, build a record, build a table of contents, get it to you, and then you can draft at your leisure.
Great.
And do you mind if I add on?
Of course.
Just, as far as, dealing with our clients, when we might come into play. So Eric and I are getting calls when somebody is served with a notice of entry. We're getting calls when an order just came down and the notice of entry hasn't even gone out. So we're constantly involved. And I know Eric was more talking about timing to reproduce a record for you, but our clients that we work with on a regular basis are calling us just to make sure that their calendar, that everything's buttoned up, that they have their 6-month deadline on the calendar, they have their 30-day deadline if they're responding to an appeal on the calendar, the time in which the last date for them to take an appeal and file a notice of appeal. And some of your colleagues, Eric and I, were just telling them, every time you have a notice of appeal, send it to us. We'll start to track it for you.
Right.
So we're, usually involved, even, maybe if the appeal doesn't even go forward. Our client may be relying on us to track deadlines.
Right, and I think that you talked about that today during the presentation, which I enjoyed because it's never a bad idea to have another set of eyes on a deadline specific task, right? I mean, Eric, you mentioned today that before extension requests were like almost par for the course, right? But now, with a 6-month timeline instead of a 9-month timeline, especially in the immediate future when people were almost planning for 9 months, these extension requests are happening more and more often. So getting you guys involved to make sure that everybody's on the same page has certainly worked out for us, right?
100%.
Right. So, and John, another thing that you mentioned today, right? While we're on the subject of cost, right? You mentioned if we had an idea of the pagination in the record, right, we could get that to you to provide an estimate almost, right? So that, even before that decision is made to use you guys on a particular case, you would be able to tell us.
Of course, because we know our clients may be about to sit down with their client and go over what's next. What are our options now that we have this decision? Now that we just filed a notice of appeal. All we need is a ballpark number of pages.
Right.
And we could certainly put together a ballpark price quote for you in return. And, of course, not all of those then come in and, those appeals aren't all perfected, so we get that.
And, from cost to likelihood of success, because that's another thing that our clients always want to know, right? I mean, if I knew the answer to that, right, I'd be in a different business, right, predicting the future. But, Eric, you mentioned today 10 to 15% is what you would expect for, the appellate division to overturn a prior or lower court case, right?
Typically, that's about right. That's what we're seeing in our experience. But that's including, and I think there was a group of us outside who discussed this. That's including, every sort of appeal,
right.
not
just workers' comp,
criminal defense appeals, personal injury appeals, medical malpractice. So taken together as a whole, I would say 10, 15, 18% on a given year.
Right.
That's probably a solid number.
Well, great. And I wanted to keep this short. John, I know you got a long drive ahead of you. I want to appreciate you guys for staying a little bit longer, right? I kind of snaked you guys to make sure that you could give us some more time. So what we do
Thanks
here,
for having us.
Yeah, what we do here with this Third Fridays podcast, I like to say, defend from day one. That's like my slogan, right? But the appeals process is a different day one, right? That adverse decision is our day one. And I say our, like our collective partnership together is our day one. And it's a good reminder to our clients that when that decision comes down, that we have a good partnership in place to put forward the right application, right? There's nothing that they are more worried about than deadlines, right? You know that, I know that.
Litigation in general and workers' comp.
Yeah, right. Like it's
100%.
We like to say it's like a gotcha industry, right? Like if you don't make it, then it's over, right? Of course, there are extension requests that may or may not exist, right? Right now, we don't like to file them because we know we can get it done in the 6 months, and we're happy that you guys are partners for that. So, for John and Eric, this is Christian reminding you guys to defend from day one.
Thank you very much.